Thank you, everyone, for attending. Again, my name is Frank Angileri, and my colleague, Marc Lorelli. I'm going to speak first, and then Marc will be second. The topics we have today, I'm going to speak on 2 Supreme Court cases, and Marc's going to speak on some significant 101 cases, patentable subject matter. It used to be you didn't get 2 Supreme Court cases in a decade. Now getting 2 in 1 quarter is pretty rare, pretty significant. The 2 cases are Quozo and Halo, and then the 3 cases that Marc's going to talk about are listed below. Jumping to those Supreme Court cases, the first one is Quozo, and this is significant because it's the first time the Supreme Court has weighed in on the AIA and the post-grant proceedings. And a couple of significant points. The most significant is probably that they were generally deferential with respect to the PTO and how they were handling their business. They also weighed in on claim construction and on appealability, as we'll get to. So the first big issue in Quozo was claim construction, and the question was whether the board would apply a broadest reasonable interpretation standard, which is common in examinations, or a Phillips standard, which is common in litigation. Well, it is the litigation standard. And at some level, there was a fair amount of discussion about whether IPRs are more like a district court litigation or more like a patent office procedure. The Supreme Court went with the broadest reasonable interpretation standard, which is sort of the patent office standard, and did not go to Phillips. You could infer that the Supreme Court may be saying that the IPRs are more like patent office procedure and less like a district court, but I don't know that you can extend that to all matters, and we'll see how that develops over the future. One of the points that they looked at was motions to amend, and this isn't really the subject of Quozo, but a big issue in IPRs right now is motions to amend. And this is a bit of a tangent, but right now the Federal Circuit is looking en banc in the Aqua Products case. They're taking briefs on the question of who bears the burden in a motion to amend. Is it the patent owner has to prove that the claim is patentable, or the challenger or somebody else has to prove it's unpatentable? And some think that one of the reasons that issue is in the Federal Circuit is that statistically a large number of motions to amend have been denied by the PTAB. One of the arguments that parties made in Quozo, saying that they argued that the IPR is more like litigation because, in part, it's very difficult to amend your claim, so it's less like prosecution. The Supreme Court rejected that notion, and they said that even though there's a high bar to amending claims, that doesn't make it litigation. Interestingly, on this sub-bullet, the Supreme Court noted that the motion to amend may have been denied because the claims simply weren't patentable. Last week I was on a panel with Chief Judge Rusky. He's the Chief Judge of the PTAB, and he put up some statistics showing that although, yes, a very small number of claims have been allowed, the reality is most of them were denied on substantive grounds. So in that regard, the Supreme Court was, without knowing it, perhaps onto something. They weren't worried, second bullet point, about inconsistency between perhaps a claim construction in the board and claim construction in the district court. They just said that's common to our system. The second big issue was appealability. And by statute, institution decisions for post-grant proceedings are not appealable. That statute has been tested heavily in the Federal Circuit, and the Federal Circuit has repeatedly held that it basically means what it says. And the Supreme Court basically affirmed in that point. Mine-run challenges, so sort of normal challenges, are barred. And there's a literal reading of Section 314D. They said it must at least forbid an appeal that attacks a decision that raises the kind of legal question a little more. So an ordinary dispute on the ordinary merits of an IPR is not going to be appealable at the institution stage, which means if the board denies institution, that's not appealable. They did, however, carve some exceptions. We've got the word shenanigans up here. It's just colloquial, of course. But the point there is, if there's something that's really out of the ordinary, the Supreme Court opened the door for a possibility of something being appealable. The first bullet point talks about the holding applying only to questions that are closely tied to the application and interpretation of statutes related to the institution decision. That's the ordinary decision. But they suggested that there may be appealability for constitutional issues or an argument that the board has gone outside of its statutory limits. We've got an example there. If the board instituted an IPR based on a Section 112 defense, which is not statutorily permitted, perhaps that would be appealable. Another option, the last bullet, if there's jurisdictional questions, sometimes jurisdictional questions can be reviewed even though the statute doesn't allow it. The bottom bullet, several petitions are now pending probing these exceptions. There are, I believe, 2 petitions to the Supreme Court right now that are addressing the constitutionality of the entire IPR process. So those are kind of big issues that obviously would be a game changer if the Supreme Court took those issues. The practical impacts of quozo. First bullet, I mentioned this earlier, the Supreme Court is taking a deferential stance. So I think that's significant, potentially beyond this case, and perhaps could be a bellwether of how they're going to approach these cases. The second one, again, it sees it more, at least thus far, it sees it more as administrative and less judicial. Again, that could potentially provide insight to on how they're going to see things in the future. And the last thing is that with the different claim construction, you, by definition, have the possibility of the board construing a claim term differently than a district court. And there's a Federal Circuit case on the bottom that talks about, quote, we can't foresee how the claim construction reached by the board could satisfy the elements of issue preclusion. And that's a Supreme Court case that talked about when administrative rulings can have issue preclusion in a district court. So I think given the different standard, the Federal Circuit is certainly indicating that claim construction would at least in theory be open under the different standard in a district court, even if the board has construed a claim. The next big case, the HALO case. This case deals with willfulness and enhanced damages. In the third bullet there, we can see it rejects the Federal Circuit's Seagate technology willfulness standard. Seagate was the Federal Circuit standard for willful infringement, and it had a relatively analytical test, which we'll get to. The Supreme Court rejected that analytical test and said that a district court has broad discretion under Section 284 to decide whether to award enhanced damages and how much. That's the big takeaway, rejecting the more rigid test and substituting broad district court discretion. This slide just talks about the background principle as well known, which is that finding of willfulness can trigger enhanced damages, and by statute those can be trebled up to 3 times. But of course the statute doesn't articulate how that's determined. This slide is the Seagate standard. So the key point on Seagate is it had 2 parts, and the first part was objective. The second part is subjective. So I'll take the second part first. The subjective part said that you had to show that the infringer knew about the potential infringement and knew it was a high risk or so obvious that they should have known. That's kind of a more traditional notion of willfulness. But the first objective prong, which Seagate added, was something different, and that's really what triggered the Supreme Court's reversal. The objective standard said that to prove willfulness, you not only needed to show that subjective awareness of high risk, but they needed to have an objectively high likelihood that the acts constituted infringement. That means that if the defendant had a reasonable defense at trial, an objectively reasonable defense at trial, even if that defendant had no awareness of that defense at the time of infringement or at the time the willfulness was being assessed, that would negate a finding of willfulness. And the bottom bullet both points had to be proved by clear and convincing evidence. I'm going to this slide. The focus here is again on that objective standard. Because that was objective, there was a question about whether it went to the judge or the jury and how you administered it. It ended up breaking up willfulness into pieces. Some folks objected, said it was awkward. The Supreme Court didn't really focus on this as much as the impact of the objective standard, and I'll get to that. All right, 9-0 decision written by Judge Roberts. They rejected Seagate and replaced it with the broad discretion. And the key point here for the Supreme Court was they said you can't have a standard that allows a really bad offender, culpable, willful, wanton, malicious, pirate, etc., to escape the 284 statute merely because they happen to have an objective defense. They said that really doesn't jive with willfulness law in general, and they felt that the objective standard prevented, or protected rather, egregious misconduct. They use that phrase a lot in the case. So they took Seagate out on that ground. The quote we have here is interesting because the Supreme Court has installed a fairly, arguably a loose standard, a highly deferential standard of the statute, but they've certainly had, there's certainly a lot of language in the opinions where they try to emphasize that this, although there's discretion, it should only be for egregious conduct. Again, I said egregious is used several times in the opinion. And so this quote, if you look at it, talks about all kinds of strong language: punitive, vindictive, egregious, bad faith, deliberate, consciously wrongful, flagrant, and characteristic of a pirate. And the reason I'm talking about all that language is I don't know that willfulness historically has required any kind of proof of that magnitude. If you go back to underwater devices in the early 80s, the Federal Circuit said you had a duty to investigate. Once you're aware of a patent, you had a duty to investigate, and if you didn't fulfill that duty, you would be willful. That's been overturned, but it's still willful infringement historically has not required conduct of this level, and it will be interesting to see whether this case influences any kind of jury instructions on the willfulness standard. This bullet point, the reason we have here is this is again the Supreme Court focusing on discretion, and they say district courts always enjoyed discretion in deciding whether to award enhanced damages and in what amount. Through nearly 2 centuries of discretionary awards, there's been review by appellate tribunals, and this is the kind of the point. The channel of discretion is narrowed so that such damages are generally reserved for egregious cases of culpable behavior. Again, this is another example of the Supreme Court, it would seem, signaling that although there's discretion, they seem to be suggesting that that discretion should be, they didn't use their words, channeled, were generally reserved for egregious cases of culpable behavior. So it will be interesting to see how this case gets applied by district courts in the first instance, and then the Federal Circuit, how they review cases. Because although these findings will be reviewed for an abuse of discretion, this language suggests that the Federal Circuit could apply that abuse of discretion standard through this channel that the Supreme Court is talking about. Other key points on HALO. It's consistent with the discretion that the Supreme Court articulated in the Octane Fitness case. That was about attorney fees. So again, the Supreme Court in both instances is giving the district court more discretion on whether and when to award them. And Octane itself potentially put fees on the table for the defendant. A defendant can seek fees. Again, it's by no means mandatory, but it opened it up in terms of the range of situations when a party can seek fees. HALO talks about willfulness being determined at the time of the infringement. I think that's the point there is, again, whether you have an objectively reasonable defense during litigation isn't the key. It's what your state of mind was at the time of infringement. Willfulness, third bullet point, willfulness historically required proof by clear and convincing evidence. Practically speaking, I don't know how often that made a difference. If a jury found infringement and they believed it was willful, I'm not sure how often the clear and convincing standard would have altered their thought process, but in any event, it's gone. And then finally, this last bullet point is interesting because it says, we say in HALO, willfulness is subsumed in the broad discretion to determine enhanced damage awards. So again, this gets to the kind of the relationship between the judge and the jury in terms of finding willfulness and how that impacts enhancement. Willfulness is a jury question, but if willfulness is applied broadly and the enhanced damage awards require that more egregious conduct, to use the Supreme Court's words, there's a question about what else would a plaintiff patent owner need to show in order to to get the enhancement, and who decides those facts? Do you present them in the jury trial? Do you wait afterwards? So these are questions that I think we'll have to see how they work themselves out. Practical impact of HALO, I guess I've covered some of these at some level. The first point is that when we say it effectively demotes the importance of willfulness, that was the point I was just making about enhanced damages kind of being a bigger issue. Second bullet point, since it's an issue of fact, it will usually be more difficult to address on summary judgment when under the past standard, which had the objective standard, that was something that could be raised at summary judgment. This third bullet point, again, is the Supreme Court's, you can't rely on a theory that arises after you commence infringing conduct, or in other words, you can't rely on a defense theory that existed only at trial. Fourth bullet point, I guess we say enhanced damages will really be modified on appeal, but I guess that remains to be seen on how the Federal Circuit, in theory, when you have an abuse of discretion standard, that fourth bullet point would be the norm. But if the Supreme Court, as I mentioned, their language could be read to allow the Federal Circuit to manage this process. And the last bullet, willfulness was very difficult to prove under Seagate. Now that it's back on the table, that changes the math of patent cases in some respects in terms of likelihood of success and like the range of possible recoveries. So that's it for the Supreme Court, and we're now going to turn it over. My colleague, Marc Lorelli, is going to talk about some developments in 101.
Hello, everyone. As Frank said earlier, it's very rare to have two Supreme Court cases in the same quarter. Well, I think the same kind of happened in the Federal Circuit here with so many 101 cases that actually changed the landscape. So it's a very important quarter for the development of law in 101. I think we did a webinar on this previously, but the 101 cases that first came out of the Federal Circuit after Mayo and then Alice, a lot of them affirmed findings of non-patentability, and part of that was because the most egregious patents come up first, and there wasn't a lot of good analysis from the Federal Circuit in applying this standard from the Supreme Court that, in all honesty, has a lot of wiggle room, and I guess that's for a reason. But what those cases led to was people just simply trying to generalize a claim. The first step in an Alice or Mayo analysis is figure out what the claim is directed to. As patent attorneys, that's new language for us. We talk about what's claimed, what isn't claimed, not necessarily what a claim is directed to. So people would just try to generalize a claim to an abstract idea in order to get past that first step. And then the second step was, well, if there's generic or old or conventional activities, those don't qualify to pass the second step, which was, is there something substantially more here? So that led to a lot of decisions invalidating patents for non-patentability under 101 at district courts. Another part of what really wasn't all that clear was the Supreme Court talked a lot about preemption in its analysis in Alice and in Mayo, but neither one of the two steps expressly discussed preemption. So that led some courts to not even consider preemption in their analysis of 101. So what we have this quarter in the Federal Circuit is a look at precisely how these different standards are to be applied. Now the next slide that we have here, slide 21, is a chart, and it comes from the Patent Office, but as far as the analysis as to how you do this two-part eligibility test, and it's really, when the courts talk about two parts here in the Patent Office, it's step 2A and 2B. Step 1 is they refer to as the claim a process, machine, manufacture, or composition of matter, and most of the time, actually pretty much all the time, it is. So the part 1 of the Mayo test, labeled 2A here, is the claim directed to a law of nature? And that's the directed to language that has led to a lot of interpretation issues. And then in step 2B, or part 2 of the Mayo test, it talks about whether additional elements are significantly more than the judicial exception, and that judicial exception being a law of nature, an abstract idea, natural phenomena. So we just have a few more slides here that pop it up there. So with this first step, I call it step 1, but it's step 2A in the Patent Office guidelines. How do you determine whether a claim is directed to a law of nature, a natural phenomenon, or an abstract idea? Those are things that the law has determined that shouldn't be patentable. You shouldn't be able to patent a law of nature. I can't patent gravity or anything along those lines. So really, how do you apply this first step? And the Supreme Court did not give a lot of guidance, but it did have this one statement that is very telling, and that's the Mayo quote that is highlighted on slide 23. Clearly, if you don't apply part 1 of the Mayo test correctly, you could get rid of all of patent law. And unfortunately, that was the direction of certain courts throughout the country, is that they were broadly applying this step 1, basically determining that most, if not, especially in the computer science and software area, that all such claims were directed to an abstract idea. And that wasn't necessarily right, but it was easy, and there was some support for it. When you look to see what the Patent Office had done in this regard, they don't know what it means to have a claim directed to an abstract idea. So what they decided to do with their examiners is give them examples. And the next slide, we have those examples for examiners to use. The examiners thought that, or the Patent Office thought that by telling the examiners all the different things that have been decided as abstract ideas, economic principles, mathematical formulas, if it's one of those examples, well, certainly it can be directed to one of those concepts, and if it isn't, it shouldn't be. That it doesn't necessarily answer the Supreme Court, but it's a guideline in order to start applying this directed to test. But even with these guidelines, courts, especially district courts, were commenting that whenever you had a claim that was directed to computer software, it was necessarily directed to an abstract idea, because software just did things that were, it performed functions, and functions could be considered an abstract idea. So a lot of courts, when they were dealing with computer software, just skipped step 1. And one case in particular that came out this second quarter kind of put an end to that, because it's hard to argue, if you're a patent holder, it's hard to argue that something isn't directed to an abstract idea when there's no opposite, there's no countervailing point. So the case that was instrumental here was Infish versus Microsoft. And it was really, the invention was, it was a concept with a database. Basically, if you think about Excel or Access, there's tables, and you can use them to put data in, and you can form a database. And what the patent involved in InFish was simply organizing that data into a certain type of table that had certain benefits and advantages over what was done before. So in the old regime, well, it's software. It's directed to an abstract idea because it's directed to tables, tables that hold data, and of course that's something that's abstract and shouldn't be protectable. But what InFish said is, no, in order not to be directed toward an abstract idea, you can. They've given an avenue. They've given an alternative argument, so the court can look at two things. One, they can look at the defendant's argument as to what the defendant is saying is directed to an abstract idea, or they can look to the patentee's argument as to what it is. And the argument that was made in InFish and now has become fairly standard is, in order to not be directed to an abstract idea, you need to have something that's an improvement to existing technology. And in this case, it was computer technology. So basically what InFish said is, because this table is directed to an improvement to existing computer technology, it isn't abstract. And this is the first time that the Federal Circuit has been able to say this in concrete terms. The Federal Circuit said it, at least alluded to it, in a case called DDR about half a year ago, but then they decided that they were still going to analyze step 2 because they weren't certain about the step 1. In DDR, they talked about if it's a technical solution to a technical problem, it wasn't directed to an abstract idea. So now we have competing arguments that can be made at step 1, and it's really up to the judge, because this is a question of law, whether it's more like an improvement to computer technology or it's simply a claim directed to an abstract idea. But it's more than just that. In order to be directed to an abstract idea, it needs to cover that abstract idea. It has to have some preemption context in it. And the court in InFish talked about the plain focus of the claims. Not necessarily what it's directed to anymore, but what was the plain focus. If the plain focus was an attempt to simply cover data in tables, well, it was going to go, the patent should not be patentable. But if it was directed to an improvement, a specific improvement on data in tables, to which computer functionality itself was used and improved, well, then it should be patentable. It should not be abstract, and you shouldn't have to worry about any further analysis under 101 and under the Alice Mayo framework. So InFish is the first and only case still from the Federal Circuit on computer software technology patentability that affirmatively stated that it's not directed to an abstract idea. The next case complements InFish fairly well as far as understanding this Alice Mayo framework, and that's the Boscom Global case. And the Boscom Global case, if you think about it, it was either at work or with your children's web functions. There's ways to filter content to make sure employees or children don't go to improper websites, and that's been around a long time, ever since the advent of the internet. The Boscom patent talked about those types of filtering or protecting people from going to the wrong type of sites. And as it said in the opinion, filtering is an abstract idea because it's just organizing human behavior. I don't want my child to go to a certain website, and filtering was just an implementation to that. Well, the Boscom patent, though, was very interesting because it talked about, as the prior art, filtering. It talked about what was done previously, how it was done locally on a computer, how it could be done at AOL.com globally for all their users of their system. But the patent itself was an improvement as to how filtering was accomplished over multiple computers. And here the court struggled on the abstraction test, the step 2A as it's shown in the slides, or the step 1 of the Mayo test. And they said it was a close call because the claims were directed to filtering, but there was more content in there that they did not feel comfortable saying it wasn't directed to filtering. So they weren't certain on that first step, so they went to the second step, or step 2B. And step 2B, as we looked at earlier, is does the claim recite additional elements that amount to significantly more than the judicial exception? So let's talk about the judicial exception. In this case, it would be an abstract idea, which the court identified as filtering. So the question becomes is, do the claims recite more than that? And in the district court opinion, as with all the other cases, they go step by step through the claim, and they say, well, this is a computer, that's old. This is a server, that's old. This is a database, that's old. And when they go through all the elements, they determine that there's nothing significantly more there because everything is old. But what Boscom said is, no, you got to make sure you look at the combination. And you look at the combination not in a vacuum, but in connection with the abstract idea that you identified in step 1. So these two steps are related. If those elements provide something more to the abstract idea than just the abstract idea, then it passes step 2. And it's not necessarily whether you have a new computer or a new computer technology, it's whether you do something more in addition to the abstract idea. The Supreme Court in Alice, as the quote is up here on slide 31, talked about we don't want claims that are simply designed to cover or monopolize an abstract idea. Well, these claims weren't trying to monopolize filtering or any type of filtering. What they were trying to cover was their specific implementation of a particular filtering that could be used over multiple computers. So really what Boscom has done is two things. Number one is it relates step 1 and step 2 of the Alice analysis so that when you're looking at step 2, you always consider the abstract idea that was identified in step 1. And the second thing that it does is it brings preemption squarely in the analysis for step 2, as the Supreme Court alluded to but did not make express. Really, 101 has been about we don't want to preempt coverage of abstract ideas, natural phenomena, known business practices, things like that, just because somebody does it on a computer. And through the Boscom decision, anything that still could be argued if it was an abstract idea, here's 2 arguments that a patent owner can use then to establish patentability once you get to that step 2. One is that it's significantly more than the abstract idea, which of course brings it right into the preemption argument. And the last point here on the slide, it's basically the preemption, and another concept that I want to discuss briefly is a lot of these early cases went off on, look, this is just a business practice that you're doing on a computer, and it's the only way to do it on a computer, so there's nothing here, it shouldn't be patentable. With this court, it says, look, even if filtering is an abstract idea, it isn't preempted by this claim because this claim doesn't cover all ways to filter. It covers the specific technological solution improvement that was claimed in this patent. So between Infish and Boscom, the 2 steps of the Alice Mayo analysis have now got more meat on them from both sides, so that now a patent owner has arguments that can be made if their claim and their invention fall under a certain technological solution, and so that the jurisprudence isn't simply just looking at it in one direction, which was primarily unpatentability for all the initial cases that were coming out of the Federal Circuit. The next case that we have here is TLI Communications. It came out right after Infish, and it was interesting because it really reiterated is just because you have computer software, it doesn't mean you're going to get past Alice or Mayo. This was a patent that talked about taking digital images, putting a timestamp on it, and organizing it on a computer, kind of similar to what people would do with their photographs that they take and put into a either a photo book or a storage drawer, things along those lines. And here the court found it was ineligible. It identified the abstract idea of taking, transmitting, and organizing digital images. And then it said there wasn't anything else there because the only other elements that were there were doing it by a computer. So the court, in distinguishing EnFish, talked about it wasn't an improvement to computer functionality because computers could do that from day one. They could use information and sort it. It's not a solution to a technological problem that's like the old Supreme Court dear, because the technological problem was just implementing something on a computer, which should have been pretty easy. And then it also did not solve a particular challenge to the internet like DDR. There was no meat or substance here other than the abstract idea. And with that, these claims were found to be unpatentable. So there's the counterpoint to the two patentability decisions that came out right about the same time. But what I think these three cases show us is there's now a workable framework that can be analyzed from both sides for not only people that own patents, but people that are prosecuting patents. These guidelines can be these cases can be very helpful because of the guidelines that they show us for the arguments or the positions or the statements that have to be made. The next slide was just the Section 2B of the TLI communications. That's the lax and inventive concept. Basically, everything is old, and even if you put it all together, there's no real step beyond simply the abstract idea. So it's not significantly more. Now, there was another 101 case this last quarter, and it's here just for interest because it doesn't really relate to the others, as this relates to a law of nature. It relates to biomedical type devices. And there was an earlier case that's talked about in the opinion at length. It was a case called Omarosa versus Sequenon. And basically it was distinguished on the fact that in that earlier case they observed a law of nature. And in this case they distinguished it because they said that the law of nature was the ability of some very technical term, hepocytes, to survive multiple freeze-thaw cycles. It understood that, it recognized that, but then the steps or the claims went one step further. It was the way to use that law of nature to improve the life cycle of these organisms. So it wasn't much of a distinction, but it was a distinction that the Federal Circuit felt that was important to make because the case earlier really wasn't all that different. But as I say with most of patent law, if you have a good invention, you sell the invention, and then typically the law supports good inventions because that's the purpose of the Constitution. If you don't have a good invention, look out, because these are the types of new rules and procedures that are going to invalidate those patents that aren't necessarily based on good inventions. And the impact. The Federal Circuit appears to be nibbling at the Alice-Mayo test. Really, it's trying to put meat on the bones. The Supreme Court, I think, intentionally left the analysis fairly skinny so that the Federal Circuit and those in patent law could develop the appropriate meat to put on those bones. I think that it's doing that, and it needed a set of cases that were much more meaty than the original ones that were coming up to the Federal Circuit in order to do that. And I think that what a good walkaway is the in-fish walkaway. If your invention is an improvement on existing technology, it's going to be good. It's going to pass. But when you write your patents and you write your patent claims, make sure that the fact that it's an improvement on existing technology is clear, and it's not simply an attempt to broadly cover existing technology. I think that brings us to the end. There is an ability to send in questions, and both Frank and I are here to answer whatever questions you have or anybody has for the next few minutes.